sorry to everyone concerned that we're starting late. It's entirely down to me.
My Lords, to give some structure to this afternoon's submission...
And you've got, obviously, until 4:30, if we need it. I'm not saying we do, but if we need it, you've obviously got...
I'm very grateful, my Lord. Well, let's see how we do. I hope I can do this relatively speedily.
Yes.
But in order to give some structure, I was intending to follow the same structure that we have drafted in our written case. So for this afternoon, I was going to firstly approach the correct approach to interpreting a registered community design. Secondly, briefly, the correct interpretation of this CRD. Thirdly, the appellate function. Fourthly, the overall impression. And then, fifthly, the need for reference. So, going straight then to that first issue, the correct approach to interpreting a registered community design. We've addressed this in our written case, and that's Core Bundle D, tab 1, page 124 to 130, at paragraphs 23, and in particular, paragraphs 27 to 38. I wish just to highlight 5 points. We say this is an objective test. You just look at the representations which are on the register. Secondly, we say it's for the court alone. No role for the informed user or design corpus. Thirdly, no rules or assumptions or presumptions apply. All depends on what is depicted. Fourthly, we agree with Magmatic that the approach to determining the subject matter of a community registered design should not differ merely because the representations are depicted in line drawings, grayscale drawings, or photographs. And fifthly, as a result, there's no role for evidence, factual, or expert when deciding this issue. That's one of the reasons why we say it's not a multifactorial assessment. Now, it's important, my Lords, to appreciate what was common ground before the Court of Appeal. Firstly, that the interpretation was for the court alone, not for any other person and not for the informed user. To make that good, my Lords, would you please take bundle H.
Bundle H.
H. And turn to page 1058 and tab 1. Oh, do you not have H?
What documents from the Court of Appeal bundle? It's not actually got an H on it.
Oh, sorry, it's a tab H.
It has that. Bottom there. Oh, it has, yes, I see. A tab H.
Tab H. Tab 1.
Okay, which page?
Page 1058.
Thank you.
Paragraph 19. This is Magmatic's skeleton argument for the Court of Appeal. It contends, we contended that as a matter of the court to assess the scope of the design. They didn't dispute it. And
they said it makes no difference anyway.
Makes no difference, exactly. Yeah. Secondly, before the Court of Appeal, it was agreed that it was the court that had to look at the graphic images pictured on the register and discern from those the information which they convey, and that is what is protected. That's what's effectively recorded in the Court of Appeal judgment at paragraph 31, last sentence. That's page 216 of the bundle.
Yep. When you say for the court to interpret the design, what do you mean by interpreting the design? Do you mean identifying which are the features that are relevant for the purposes of the Article 10 comparison?
Yes, but before you get to Article 10 comparison, obviously, you need to identify those features anyway, because obviously you need to identify... often.
That's what you are referring to when you talk about interpreting the design.
It is indeed. That's right.
Understood.
The reason I certainly cavil about Article 10, obviously, we would have to do it for the purpose of novelty, for example, which we're going to come on.
What you're saying is for all purposes?
All purposes, that's right. Okay. Yeah.
Yep. So you've got paragraph 31, last sentence on page 216.
Exactly. And there was no suggestion for the Court of Appeal that the court should take into account the design corpus or any evidence when interpreting the design. And as I understand it, at first instance, there was no suggestion before Mr. Justice Arnold that he should take either into account when interpreting the design. And certainly from the judgment, there's no record that he did or that he considered it relevant to do so. Thirdly, whilst there were and are some established conventions for interpreting registered design, it was agreed that these were in any event mere conventions and not rules of law. That again is recorded in the Court of Appeal judgment at paragraphs 31 and 32. None in any event applied to the facts of this case, save for the question of absence of colour, as opposed to colour contrast, which it was common ground did not form part of the CRD, or the Community Registered Design. Fourthly, it was common ground there was no inconsistency between the Court of Appeal's respective decisions in Procter & Gamble and Apple and Samsung. And that again you'll see in Bundle H expressly at page 1065, paragraph 50.
Thank you.
I should just say that there may well have been a confusion in, if one turns to that, my lords.
Well, it suggests that you say there was, and they say there wasn't.
That's right. We didn't anyway.
You're now saying there isn't.
So we said there never was an inconsistency. They seem to think that we did, but they certainly didn't think there was an inconsistency before the Court of Appeal, and I'm not entirely sure now whether they're actually residing from that. I don't think they are, to be honest. And neither party before the Court of Appeal relied upon any inconsistency between the English court's decision in Apple Samsung and the decision of the invalidity decision in OM. Now, it does appear from my learned friend's oral submissions that he is now suggesting that this court should take a different approach, and Magmatic themselves are taking a different approach. Firstly, to take into account the informed user, and secondly, to take into account the design corpus when interpreting the community registered design. As to take into account the informed user, we say they're wrong in law for the reasons which we've set out in paragraphs 30-32 of our written case. This was an issue which was before Mr. Justice Burse,
yes,
and he addressed it head on. It's wrong for my learned friend to suggest that this was a decision that the judge then found it was a question for some technical addressee to construe it. The submission from Mr. Howe before him was that it was for the court to address, and that's a submission which Mr. Justice Burse accepted. Secondly, neither the informed user nor the design corpus is taken into account when you consider the novelty of a registration. And again, in paragraph 41 of our written case, we've given the two cases which are frequently cited for that. That is those at the footnote 34, Lord Justice Jacob in Green Lane and Norman Copenhagen, which is Owen Board of Appeal. Thirdly, the concepts of informed user and design corpus are only relevant to individual character and infringement. They only come to play with Article 6 and Article 10 of the regulation. They're not mentioned in relation to Article 5. And as my learned friend took you to, design corpus isn't mentioned in the body of the regulation at all. It's only mentioned in the recital, that's recital 14, and that is addressing solely the question of individual character. No authority is cited by Magmatic for the proposition that design corpus should be taken into account for the purpose of interpretation. Now, to be fair to my learned friend, he did cite, or did refer to the Dutch and the German decisions in Apple and Samsung for the proposition that perhaps there's a role for the informed user. Our respectful submission in relation to that is that on the facts of this case, it's irrelevant because he agreed it wasn't an issue for this court. But secondly, it's not clear from either of those decisions, actually, as to whether or not the issue of informed users as opposed to the court was actually in dispute between the parties anyway. Now, on that basis, we say it's not open or it's not entitled to suggest the Court of Appeal have erred in any way in not taking into account the design corpus or the informed user when interpreting the registered design. And on this context, my lords, could you turn to paragraph 55 of Magmatic's case? That's tab B, page 78, the core bundle. B1, 78. paragraph 55,
Yes.
they assert that importantly the Court of Appeal did not have before it examples of suitcases brought to court by PMS, as well as those exhibited the witness statements which formed the design corpus when reaching the conclusion. That's absolutely correct. They didn't. The Court of Appeal didn't. It wasn't brought to their attention by Magmatic, nor was it suggested that any time they should be relevant. They did not suggest they should take those into account. Now, the examples which Magmatic have now sought to put before you, my lords, are behind tab 2 of that same bundle. Could you turn to those, please? The first one is at page 85.
Yeah.
My learned friend took you through these briefly this morning.
So these are new here, are they?
These are the new ones which weren't before the Court of
New
Appeal.
here.
That's right.
And they weren't at first instance either.
They were first instance, not before the Court of Appeal, back again for,
Okay, so the
for this
judge.
court.
Okay.
Oh, they were at first
They
instance.
were first instance.
Yeah.
And these were, as I understand it, these were formed some of the designs that formed part of the design corpus which Mr. Justice Arnold relied on. And of course, you need design corpus for the purposes of considering infringement, but not for the purpose of interpreting the design. Now, all of these, my lord, I want to make a few submissions in relation to all of these images have plain, unadorned surfaces. None.
Making submissions in connection with infringement now.
No, I'm making submissions in relation to my learned friend submission.
I see.
That if these...
You say if you're wrong and these are relevant, then these are your submissions.
That's right.
Okay.
That's right. So assuming these should be taken into account, I'm trying to develop my learned friend's submission. Where does he go with this? Because what we say is that when you look at these all reinforce our submission as to what any person would interpret the community registered design to be, because they all have unadorned side surfaces and front surfaces. They're plain. None has sides or fronts which are highly decorated. Some have a specific tonal contrast. For example, if you look at page 85, you have the single body colour yellow, but you have the contrasting black central strip. You have on page 86 the single yellow colour of the body and the contrasting black tone of the wheels. 88 doesn't assist anyone at all. 90, all are single colours. 92 is a single colour, single tonal case with contrasting black wheels. 94, single tonal case with contrasting tyre as opposed to central hub of the wheels. 96 appears to be single tonal colour for the case and a contrasting black wheels in the bottom right hand corner. 97 appears to be a substantially black case with a contrasting tonal contrast being the central strip.
I think we have the point, yeah. Yep.
So none of those, we say, would support my learned friend's submission. If you took those into account, that somehow you would come to a different interpretation of what the community registered design would be as opposed to the decision taken by the Court of Appeal. Now, so that leads us on to the final point about this issue. So even if it were to be correct that you could interpret the design through the eyes of an informed user, taking into account the design corpus, that would not have meant that the Court of Appeal would have come to a different answer. We know that the informed user is merely a parent or care or relative. That the Court of Appeal accepted from Mr. Justice Arnold's judgment, and the design corpus is as we've just seen it. There is no support for what Magmatic wished to suggest to my Lord this morning, and have stated in their case at paragraph 48, page 76 of the bundle.
Yeah.
Penultimate sentence. The products in question are likely to be highly coloured and decorated when made. There was no evidence before the first instance judge that that was the case. There's no evidence from the design corpus that was the case. So there is no basis for them to suggest somehow that you would take that into account when interpreting the CRD.
If they were for children, which I understand it's common ground they were, isn't that a possible inference that could fairly be drawn?
No, my lord, not as to the. This is one back.
That's making the mistake of confusing the design claim with the eventual product.
That's absolutely correct, my lord. And also remember that the design is not limited to a final product. So this design, this gives them a monopoly in this design as applied to any product. This could be, I think, the suggestion I gave in the Court of Appeal. This design could be applied to the shape of a sponge, and that would give them an absolute monopoly in relation to that. So it's illegitimate to suddenly suggest that actually, because one particular example, a child's case, may subsequently have coloured tones on it. It's legitimate to construe that as to what they're actually seeking to protect. So what we say is that if you were to take into account the design corpus which they have identified, it would actually reinforce the submission which we have made, which is there was a deliberate choice to have a tonal contrast between the wheels and the contrasting strip feature, and a deliberate intended part of the design to have unadorned or unornamented single tonal sides.
Well, now, I wonder about your last comment, because when you look at the registered design, you can see that it is something that is intended to be sat upon, and it seems to me fairly obvious that from the adornments that such as it has, that it is directed towards children. Are you seriously suggesting that this particular item is something that adults would buy and go riding through airports on?
This design, my lord, gives them an absolute monopoly in this appearance of a product to whatever product in the world it's applied to. This could be a necklace charm, this could be a sponge, this could be a suitcase.
Somebody made an aerosol spray in a bottle shaped like this.
That would also infringe this monopoly.
It was registered for suitcases, though, wasn't it?
That's right, and as my learned friend quite rightly pointed out, that's purely for administrative purposes. It helps to interpret, arguably it helps to interpret what you're seeing, but it's not in any way a limitation.
So, yes, it could be used for necklaces and so on, yes, but...
Where does that get you? I grant you that that's the effect of the registration. You could make sponges or mops or anything else you wanted out of it. Where does that take you?
It gets me away from the submission which my learned friend is making, which is that once you interpret this, taking into account design corpus and take into account, he says, children's suitcases, you automatically assume that cannot be for the protection of unadorned signs, because you automatically assume that these sort of suitcases are going to be highly coloured with decorative motifs. I say that assumption doesn't even apply. It's an illegitimate starting point.
Oh, I see. You're reading it as a positive claim to an absence of ornamentation.
I am indeed.
I see.
Because what I am saying...
I see how it gets you there.
That's right. I'm saying that is the image they've chosen to protect. That is what they've chosen to register. How do you interpret that from the visual cues that you're presenting?
You can use the fact it's for suitcases as an aid to interpreting it.
I say you shouldn't do at all.
Ah.
What I'm taking on board is if my learned friend is right, that you somehow should take into account design corpus, which is what he says you should do, that what you learn from design corpus fully supports my case, that if it were to be legitimate to use those suitcases to interpret this, which we say is not, then actually the images which you're getting from that design corpus feed into our submission as to what the Court of Appeal found in any event.
The assumption behind the submission that you are at the moment rebutting is that if the corpus has certain features, the starting presumption has got to be that unless in some way excluded by the image, the same features are to be protected under the registered design.
That's what we have to assume. It hasn't been.
That's the import of the submission that you're rejecting.
It must be, because what we have difficulties standing on this side is, of course, these are thrown up as concepts by the appellant, that this is something that should be taken into account. But he doesn't then lead through to say, so how should those be taken into account when interpreting these designs? And for the reasons my Lord Sumption has given, we say the only logical basis of saying you must take it into account must be, for the reasons just given, to reinforce what you're seeing here by reference to what you see in the design corpus. Now, to be absolutely clear, we say that's a completely inappropriate and wrong way to construe this registered design. But if it is something which you take into account, we say it feeds entirely into our construction of what this is, which is one specifically for tonal contrast and specifically for lack of adorned sides. So the reason I emphasize that is that this leads on to their reference question number 3 and the controller's question number 2, which is that assuming, therefore, you should take design corpus into account, no matter how you take it into account in our respectful submission, it can still only end up with a result which we say supports the Court of Appeal's decision. And there's no explanation given by my learned friend as to how, if you take it into account, you come to any other conclusion. That deals with what we wish to say in relation to the correct approach to interpreting the registered community design.
Could you just clarify for me, when did the idea of tonal contrast come into this case? Was it something argued before the judge at first instance? If we were in particular, talking of in particular.
My Lord, I wasn't at first instance.
I just couldn't trace anything of that in the judgment, but I may be wrong.
Yes, I am not sure to the extent to which it was emphasised at all before the first instance judge.
So it may have been a point that was raised simply in the Court of Appeal.
It certainly was raised heavily in the Court of Appeal. Let me just consult. So I understand it wasn't specifically relied on as a feature by my client, but the contrasts were pointed out to the judge, but it wasn't specifically relied on as a feature per se.
And just to come back, you say that it isn't permissible to take the suitcase description into account, essentially because of Article 36.6, is that
Yes.
right? It can't affect the scope,
Can't affect
which
the
means
scope.
it can't widen it or narrow it.
That's right.
That's your point.
What you've got all the necessary visual cues from the graphic representation anyway. You can see prima facie it looks to be for a suitcase or suitcase-type object. You don't need to have any textual description.
I understand. So it's to help interpret, but you can't use it to define the scope.
Well,
it's a little self-contradictory, isn't it?
I mean, there is some of the commentaries sometimes give examples of what appear to be images of objects such as triangles, and it seems very difficult when you look at them as to what they're actually trying to depict. And the description sometimes says hammock, for example. And as soon as you see a hammock, then you understand exactly the sort of imagery they're trying to depict. So I'm not saying no one has ever suggested they play no role in terms of guiding you as to what you might be viewing. But the primary submission should be, in our respectful submission, is that you get all the visual cues from the depictions as set out in the registration. Now, the next topic is the correct interpretation of the CRD itself, the community registered design itself. I addressed this relatively speedily for the short adjournment. I would just wish to make the following additional observation. By choosing to file the registered design in this form, Magmatic have chosen to make a number of design choices which were entirely in their own hands. They didn't need to make them. Now, these include, firstly, deciding to use a CAD rendered drawing as opposed to a simple line drawing. The particular form which they have chosen to use is very close, or we say almost analogous, to submitting a black and white photograph. It's akin to a black and white photograph before you make the product. Now, as we've set out in our written case, it's long been known that a simple line drawing which only shows contour lines is likely to result in the broadest scope, like it's only protecting shape alone. So, for the reasons set out by Dr. Martin Schrotelberg, which we've set out in paragraph 38 of our written case, the more photographic the image is, the more an objective viewer of the representation is able to perceive different and additional features to that of shape, namely surface structure, materials used in the design, reflectivity of the surface, and so forth. They could have filed a simple line drawing. They chose not to. So in those circumstances, we say the Court of Appeal was correct to observe, as it did in paragraph 41, that these are computer-generated three-dimensional images which show the suitcase from different perspectives and angles and show the effect of light upon its surfaces. They're depicting information about the surfaces in addition to merely the shape of the product. Secondly, they chose in these CAD drawings to depict distinct tonal contrast between some of the adjacent component parts and not others. So as I pointed out, the wheels and the sides of the cases, but not between the clasps and the side of the case. And as Magmatic accept in their own written case, they could have filed a rendered CAD in which there was no distinct tonal contrast at all. So in our respectful submission, if a party chooses to do that, it must wish to seek to protect those features as features of the design. After all, how else can a designer identify the features it wishes to protect other than by filing it in a graphic representation? Now, in those circumstances, what we say is protected by the registered design is as was held by the Court of Appeal. We've summarised that in paragraph 53 of our written case. And we do say, in contrast, the trial judge's analysis of what was described and depicted was a very meagre and incomplete description. That's set out in paragraph 31 of Mr. Justice Arnold's judgment. We've set it out in paragraph 55 of our written case.
134, yep.
The total and complete analysis which he approaches in relation to what is protected is a one line from paragraph 69 of his judgment, which we set out in paragraph 54, my Lord. And in our respectful submission, clearly there, he did not analyse the features depicted and failed to consider the overall appearance. Now, my learned friend sort of suggests this morning that Mr. Justice Arnold found that the contrasts in tones showed shadows and not contrasts in tones themselves. Well, if that's what Mr. Justice Arnold was doing, he certainly didn't reduce that to any description in his judgment. Now, as a consequence, we say, and as we set out in paragraphs 59 to 60 of our written case, what the Court of Appeal did was to do the proper analysis of what the representations depicted, and therefore, likewise, what was protected. That then leads me, my lords, to the appellate function, which we've addressed at paragraphs 66 to 80 of our written submissions.
I don't think this is very
Contentious.
This is neither contentious nor do we need to be told it, I think. If the judge didn't go wrong in law, then the court should be very slow to interfere with him. If he did, then they are effectively often obliged to, and certainly normally entitled to, unless they think it made no difference.
That's very helpful, Lords. And I suppose the only point I probably ought to just re-emphasise is that in Magmatic's case at paragraph 11, so that's page 66 of the core bundle.
Yes.
They, when relying on Samsung and Apple, the submission seems to be that because this was a case relating to registered community designs, it must involve a multifactorial analysis. Well, that's clearly as a submission not correct in our respectful submission. The key issue which was before the Court of Appeal in Apple and Samsung, upon which that comment was made, was specifically the question of infringement. And in respect to that, could I just make that good? If you take the Authorities Bundle, Volume 1. Tab 7, page 439. picking it up at paragraphs 25 and 26, what the judge then is, what the Court of Appeal is then doing is, having got rid of the minor skirmishes, it turns to the main question: was the judge wrong in assessment of a different overall impression to the informed user? That's the infringement question. And in relation to that, my lord, that is a proper multifactorial analysis. There are 4 steps to that. You have to determine who is the informed user. You have to determine the nature and extent of the design corpus. You have to determine the extent of the design freedom, all in which involve or potentially involve evidence. And then finally, you have to make the 4th value judgment, which is to determine the extent to which, on the overall impression of the respective designs, whether they produce a different impression on the informed user. And for my lord's note, the fact that that is a comprehensive 4-step process has been confirmed relatively recently on the 10th of September of this year in the Hennis case by the General Court. That's in the 2nd volume of the Authorities Bundle, G, tab 20, page 726, paragraph 32.
Thank you. Paragraph
Now that is not
34. So did you say 72634? Is it 727? 32. Okay, thank you.
Can I just ask you, I think this is the appropriate point at your argument at which to ask it, but if it's not, tell me.
No, I'll try to
Paragraph 47 of the Court of Appeal's judgment, in the judgment of Lord Justice Kitchen, he is talking about the comparison that falls to be made, and what the Lord Justice seems to be saying is that it's wrong to disregard the ornamental elements because, I'm looking at the break in the page and just over, because it significantly affects how the shape strikes the eye. Now, as I understand it in that passage, but it may not be entirely consistent with what he says earlier, he is saying the decorative elements are relevant to one's analysis of the shape, whereas, as I understand your submission, you're saying that the decorative elements are actually a relevant point of comparison in themselves and not simply for what they tell you about the shape.
Yes, I do. I do say that, and I think it's slightly inelegant language, but it is explicable if you then look at what Lord Justice Kitchen is saying in 41,
yes,
which is he's taking into account those the lack of ornamentation on the flanks and on the front as something which emphasises the particular appearance of the product, namely as a horned animal, from its shape as well. Now, there was a debate this morning about whether or not you could effectively perceive a horned animal, whether or not it was coloured or not. And from our side, we think Lord Justice Kitchen has in mind here is that actually the overall impression which you see from the design is a factor both of the shape and also the lack of ornamentation leading to that overall appearance. The reality is, my learned friends' clients sell the same shape of product as fire engines. Once you start decorating them in a different way, it gives a totally different overall impression.
It may do.
It may do. Our submission, but that is not, in a sense, that's not relevant for this part of the case. What's relevant for this part of the case is what is this particular registration, and because this particular registration has the unadorned sides and the shape, those two feature together to give the overall impression which he is considering to be depicted in paragraph 41. And therefore, when he goes on and addresses that in relation to 42, it is in our respectful submission him taking into account those two elements in a combined fashion.
Now, a related question, which I also asked your opponent, why do you say that Mr. Justice Arnold decided that it was only a question of comparing the shapes? Now, I'm not asking for your submissions on this point, which I think I understand, but what's your analysis of his judgment as to his reason for saying that? I mean, he could have been saying Looking at these two objects, making the Article 10 comparison, the shape is what strikes me as the only thing that matters. Or he could have been applying some other principle to make the shape the only thing that mattered. What do you say he was saying?
I personally have difficulty understanding what he was doing at this stage, because it is possible he just briefly did not see the tonal contrast, just saw it as shape. It's possible he went through a process whereby he saw it and then somehow discounted it and considered it to be irrelevant. I personally, my lord, I'm not able to assist you in terms of getting into the mind of the judge as to the reason he did what he did. He certainly has come to a conclusion without any reasoning that it's shape alone. What I would say is that whether he thought that's a question of fact or a question of law, he immediately gave permission to appeal in relation to it. He thought there's a matter of principle that needed to be reviewed.
He says it in terms in paragraph 69 of his judgment, second sentence. The CRD is, page 255, the CRD is evidently for the shape of the suitcase.
Yes, yes.
And I suppose, to reformulate Lord Sumption's question, is that the first time that appears? That, not that precise words necessarily, but that observation appears.
Well, the only other approach is right at the beginning of the judgment, when he only just at 31 and then at 69. 31, he asserts in the last sentence, it will note that the representation of COD are all monochrome and do not show any surface decoration. So it appears that he has immediately, by surface decoration, he seems to have discounted any tonal contrast straight away. It appears that he's looked at these, dare I say, briefly. I mean, it was an expedited trial, he had a number of other issues. It appears he's almost just simply looked at them and thought, all I see here is shape.
I mean, the reason why I wonder whether he is treating this as a question of principle or simply a response to these two items is that he formulates the question in paragraph 66, which he describes as controversial.
Yes.
As you say, it was included in among the points of law that he thought should go to the Court of Appeal. But he summarizes the parties' submissions as being that the graphical designs on the surface of the kiddie case are to be ignored, whereas your submission is that they are to be taken into account. I mean, the whole of this section, 66 to 69, looks to me like a statement of principle, although the judge hasn't favoured us with a description of what the principle is.
Lord, I understand my Lord's point. I perceive it's this, that in Procter & Gamble, the principle was not what the registered design depicted, because that appears to be common ground. The registered design was for shape. The principle was, what's the relevant comparator? Should you take into account features other than shape? And that's what was then abandoned in the Court of Appeal. So he seems to be suggesting he's already assumed its shape here, and therefore what seems to be, what I understand this passage to be, is that the counsel for PMS was seeking to run the same argument that was run in Procter & Gamble. Despite this only being for shape, you're now allowed to take into account the surface decoration which is in the accused product.
I mean, he seems to be taking a leaf out of Lord Justice Jacobs' book, because his language is identical to in that sentence in paragraph 69, is identical to the language in the third sentence he quotes in paragraph 67 from Procter & Gamble, evidently for a shape.
Absolutely.
And to be fair, Lord Justice Jacob doesn't give any reasons either.
No, he doesn't. But then,
I'm not saying he should do, I'm just saying he doesn't.
But in the Procter & Gamble case, of course, this issue, by the time we got to the Court of Appeal, had been abandoned.
Common ground.
And I probably ought to just make good the point I'm making about Procter & Gamble. If one has the authorities bundle and turns to first instance Procter & Gamble, which you'll have at tab 4, and pick it up at page 344.
Right.
Paragraph 27. Between 27 and 29, Mr. Justice Lewison is considering what is protected, and he makes a number of general observations. He doesn't as a matter of fact in these paragraphs say specifically, and therefore the registered design itself is for shape alone. But it is, we say, implicit when we come to the next passage I'm going to show you, that is what he's done. He's looked at the line drawings and he's made an observation that obviously monochrome line drawings are likely to be shape, or if they're only depicting shape or contours, are likely to protect that. Because then, when you get to the key passage, which is at 44 through to 46,
Yeah.
under the section of what is being compared, 44, the last sentence, plainly in my judgment, the first of the comparators is the registered community design itself. But what is it to be compared with? And the rest of the analysis is not, therefore, considering what is protected as what is shape, is having assumed that shape is the relevant comparator, what am I now allowed to look at in terms of the infringement? And the rest of the argument, run by Mr. Carr through to paragraphs 50, are on the basis that I'm allowed to take into account on the infringing article other elements. It is the classic like-for-like comparison analysis. And that you'll see when you get to paragraphs 71 through to 73, is what then Mr. Carr asked him to decide as an alternative if he was wrong. What am I comparing? I'm assuming it's the shape of the registered design, but I'm asking you to compare now effectively the infringing product in a denuded form. And that is what was then abandoned, those paragraphs, what Lord Justice Jacob then acknowledged was then abandoned in the Court of Appeal by Mr. Carr under a little bit of pressure from, no doubt, a certain member of that tribunal. So in our respectful submission, what it appears to be, what I am loath to get into the mind of Mr. Justice Arnold in these paragraphs, what he appears to be thinking is that the same argument that's already been run and rejected in Procter & Gamble has been trying to be run against me again. But in my position, I don't have to go there. I don't have to try to justify what Mr. Justice Arnold is saying there. What is quite clear is that he has made a finding that it's shapeable.
Yes, and the reason why it matters is that if his finding was based on the overall impression it made upon him, as opposed to a question of principle, then that adds force to the submission that it's a matter for him and not for an appellate court.
If that be the case, Bob. But even if it were to be the case, and our fallback position obviously in relation to that is that if it's wrong, it's wrong. As a matter of principle, these registered designs have to have one meaning. They don't have, there's not a discretion as to what they may or may not mean. And that is effectively the substance of our submission in relation to the appellate function, that there is, when interpreting a community registered design, there is no latitude which the appellate court should give to the trial judge. If he's got it wrong, it should be corrected. Now, following that, that's Magmatic's primary case is multifactorial assessment shouldn't be interfered with. If they're wrong about that, they have two fallback positions. The first fallback position is that in any event, the judge had already conducted an infringement exercise on the basis that the community registered design included the features of tonal contrast and lack of surface ornamentation. And that is what they submit at paragraphs 64, 72.2 and 73.3 of their written case. And my learned friend took you very briefly to certain passages of Mr. Justice Arnold's judgment purporting to support that. We say they simply do not support it, and I can do that most briefly by going to Magmatic's own case in Core Bundle, tab B, page 79. Dealing first with the issue of tonal contrast. Tonal contrast obviously was identified by the Court of Appeal in its judgment at paragraph 42. And to support Magmatic's fallback position to say, well, actually tonal contrast was taken into account by the judge, and the passages they rely on are those which they've set out at paragraphs 60 and 61 of their case, and those are not support for the fact that the judge took into account tonal contrast at all. All they are doing is the judge took into account the particular feature of the wheels in the context of whether or not they were concealed or not. And that's actually flat contrary to what the judge said he was going to do. So if one looks in the core bundle at F tab 6, paragraph 74, page 257, 258. Where at paragraph 74, certain of the tonal contrasts were identified, prominent animal markings and eyes at the front. At 75, the judge says, those items must be ignored for the reasons I've given in paragraph 68 above. So he positively seeks to ignore those. And similarly, in relation to...
What he's ignoring are the prominent animal markings of the eyes.
Yes,
it's not tonal contrast.
No, you're right, my lord. But what he's ignoring is anything other than shape. So he's saying in terms, all I'm going to take into account is the shape.
Right.
Only features of shape are going to be considered. And then the second aspect, lack of adornment of the flanks. This is in, going back to Magmatic's case, page 79. That's actually paragraphs 57 and 58. 57, 58. They seem to assert that the judge took into account the animal shape of the product. But what the judge did not take into account there is the lack of adornment on the surface of the front and the flanks of the product, which, as we have submitted, certainly emphasises, but is actually a different feature to the particular shape and the stylized image of the product itself. So, in our respectful submission, Magmatic do not have this second fallback position, which is if it's right that the judge failed to do a like-for-like comparison for those features which are depicted and claimed, there is no support in that first instance judgment for the fact that that exercise has been done, and on a multifactorial assessment, it's found not to be sufficiently close to be the same. Now, that then leads them to their final fallback position on this appeal, which is effectively to say that you can only be sure that the Court of Appeal was right in their interpretation of the registered design if the Court of Appeal was right to assume that the definition of design includes the absence of ornamentation as a matter of law within the meaning of Article 3 of the regulation. Secondly, if the Court of Appeal was right to presume that a lack of surface decoration on a grey scale drawing means that the design specifically seeks to protect shape and the absence of surface decoration. And thirdly, that the Court of Appeal was right in holding that distinct tonal contrast was a feature of design because a grey scale representation, even with tonal contrast, should be understood to be making no claim to any particular relative colour. Now, those are effectively their questions 1, questions 2, and questions 4 of their proposed reference. In very brief answer to those, in relation to question 1, our submission is that the Court of Appeal was right to assume that the absence of ornamentation was, as a matter of law, protectable as a feature for community registered design. We say it's at Clare, and in a moment I'll come to it to the extent I need to re-emphasise what we've already said in our written case about that. Secondly, their second question was that the Court of Appeal was right to presume the lack of surface decoration. Well, we say there's no support for that at all. The Court of Appeal made no such presumption or no such assumption. It looked at it afresh. Thirdly, as to...
How would you show absence of ornamentation? You say that you would show it in this way rather than, if you're claiming all ornamentation, you'd have a diagram. Is that right?
You have a
what diagram? You'd have, as in Ms. Justice Lewison's case.
Yes, I mean, obviously you could have a line drawing
If you have a line drawing, that covers, that means you're in this case, with a CAD drawing, you're with no differentiation apart from the wheels. You're not claiming any decoration. With a line drawing, you're claiming every decoration.
It depends what the particular line drawing is, my lord, obviously. Line drawings are more likely to be understood and to be prepared just to show the contours of the product. If they show just the contours of the product,
right,
they're just claiming shape.
Now, once you start shading it in and colouring it, obviously different considerations apply.
That's right, and specifically what happened in Apple and Samsung is they started shading it in even with a line drawing. So in Apple and Samsung, well,
I understand.
let's go straight away. If you take, what they did cross-hatching on the top surface. So it's not as if line drawings per se means it's only shape. It wasn't shape in Apple and Samsung on any of the drawings. No, I'll come make that good as well. They all found shape and surface and some aspect of the surface.
What do you say? Sorry, what do you say about the suggestion that if you include a specific design, you would then need to register 101 designs for every shape of whisker or variant of colour and so on? I mean, you might say, well, tough, or you might say that's not the consequence at all.
If you wish to register a particular design, that's your choice. Mm-hmm. If you want to have the widest possible monopoly and you only want to register a design for a particular shape, that's also your choice. If you want to choose something in the middle ground, that's also your choice. On the facts of this particular case, they have, for whatever reason, they've chosen a particular middle ground. There may be very good reasons for that. You'll have seen from the agreed facts and statements that, of course, this isn't a case in which this isn't a dispute in which there were no prior designs. They had their own prior design. They had a prior UK registration. That, unless they were very careful, that could have applied to invalidate any subsequent registration. So any registration they needed to apply for had to be carefully crafted so it took into account that registration. So that's a particular fact on this case. But as a matter of proposition, you are, as an applicant, completely open to decide how you want to protect it. You're completely free to do so. You choose the extent of limitation you want to put in that representation. Now, also, as you've seen in the case, the actual registration process is remarkably cheap. There is no process of vetting for validity. You can, if you wish, apply for many, up to, I think it's up to 100 applications at the same time on a very cheap basis. If you wish to protect a particular series of particular colours or particular tonal contrast. So, as a matter of policy, bearing in mind that what's the purpose of having this register? It's there to give certainty to third parties. If you choose to introduce into that register images which depict certain features, the third parties should be entitled to rely on that as being something which you have chosen to limit or scope or seek to protect as your design. Otherwise, why put it in? Now, I was going to address you just the third limb of their fallback position, which was the Court of Appeal correct in holding that distinct tonal contrast was a feature of design, because in Magmatic's submission, they are suggesting that there is a question which the Court of Justice needs to determine, which is that there is an irrebuttable presumption that when you register a grayscale representation, even with tonal contrast, that should be understood solely to be a representation seeking to depict shape alone. We say that it's act clear against them if the representation visually conveys features of tonal contrast. They are features of the design, and the fact that it's in any particular form of representation, whether it's grayscale or photographic, is irrelevant. It is something which you're sought to protect. And what my learned friend didn't seek to address with you at all this morning is that there are at least two cases which are flat contrary to his submission, that grayscale tonal contrasts are actually, for the 3D product, are considered as protecting those tonal contrasts. And I wish to take you to one of them and give you references to the second one. So the first one is Wibbit Sports, which is the District Court of The Hague, which is in the authorities bundle G tab 23. Second authorities bundle.
Thank you.
Tab 23, and I can take you first to paragraphs 2.21, starting at page 755. This is
I'm awfully sorry, I missed the reference. It's where?
So I apologise. It's in second authorities.
Yep, got that.
Model,
Paragraph?
tab 23, paragraph 2.2.1.
Thank you very much.
And Wibbit had a number of community registered designs. In total, they're relying on 14 in these proceedings. These proceedings were for infringement, and they all related to inflatable water toys. And as a defence, approximately 4 or 5 of these designs were challenged for novelty, and then the court had to consider infringement in relation to all of them. The two particular designs I wish you to particularly have regard to are those set out at 223 at page 756, and especially at 225 at 757, which is the easiest one to interpret. This is effectively a rectangular inflatable, which has, if you see the 4 images in the middle of the page, top left-hand one is a perspective image, the bottom left is a top plan where you see the 2 shorter sides being in a darker grey, the longer sides being a lighter grey. The top right is a side view, and the bottom right is a long side view, showing the front side of the product. Then, if one goes to paragraphs 3.1 and 3.2 of the judgment, which is at 772, you'll see that the claim here was for infringement, and there was a challenge to the lack of novelty in relation to those two, amongst others, those 2 designs, which you can see at 3.4 and 3.5 of the judgment. And that challenge was on the basis of the prior art designs for more conventional inflatables, which you can see at page 768 of the judgment. 2 images from 2 patents, 2 earlier patents.
Yeah.
And then, my lords, if you can turn to paragraphs 4.4 and 4.5, where they are considering the validity case, you'll see that what the court comes to is the conclusion that it's the 2/3 of the way down 4.4, when looking at the community design shown in 223 and 225, they have surface division, which they showed lighter and darker shades of grey, which are lacking in both senior designs. The shades of grey shown in there, I submit that means the senior designs, and I'll make that good in a moment, are shadows indicating depth, not indicating a difference in colour.
So sometimes they do and sometimes they don't.
In terms of the prior art designs, they are just simply showing depth, and there's no reference. They're the ones you see at page 768.
Yep.
They're not showing colour contrast.
They read it, do they, sorry to go off at a tangent, beginning of 4.4, the informed user, do they rather than...
They do. My Lord, standing back from this, the informed user is mentioned in a number of these cases, mentioned in the Appellant Samsung in the Dutch court and in the German court. I don't get away from that. It's not relevant to the facts of this particular case. We say it's wrong as a matter of law, but it's not relevant to the facts of this case because it's common ground. But I would make the submission that in none of those cases did the issue of whether it's the court as opposed to informed user ever raise its ugly head. The first time that seems to have ever been raised was in the sealed air case, which was addressed by his, Mr. Justice versus now it's...
Yeah, I just wanted to be sure that that...
No, you're absolutely right.
Yep. So we looked at 4.4. Did you want to go on to 4.5?
Then what I want to take you to is the infringement case, at 4.9 and 4.10.
Yep.
And therefore, what you're seeing in the third sentence, specifically at 4.10, the design registrations in lighter and darker shades of grey should be understood as design registrations of those shapes using surfaces of a lighter and darker colour in any colour. The use of grey, basically not a colour, without mentioning that it only regards those specific shades of grey, will make this sufficiently clear to any person consulting the register. The element of striking primary colours, etc., will ensure the products are different from the will be therefore dismissed. So this was a case where you had a 3D product being represented in a materially identical form to the representation in this case, where the Dutch court has held that those tonal contrasts are to be understood as being colour contrasts and not for shape alone.
Yes, that is what it says, although interestingly, they read in that particular case as meaning two different shades of the same colour, rather than, as you read these, as two different colours. But there we are, that may not be fatal to your argument.
You may well be right.
Yes, and all this was argued before the court at first instance, while the two-tonal issue was not argued before the English court in this case at first instance at all, as far as we can see.
So, as I understand it, that's correct.
Yes.
Yes. As my learned junior quite points out, when you're looking at 4.4, you are looking at the question of invalidity on the basis of lack of individual character. So the use of the informed user is actually the correct test in any event.
Thank you.
That would be consistent with the article expressly, yes. It would be consistent with the regulation.
That's right,
expressly,
absolutely.
yes.
Absolutely. Yeah. And the second case is the General Court in Eric Kastelhot's. That's in the Authorities Bundle, Volume 2, tab 18. If I can just give you the references, my lord. They are paragraphs 2 and 3 for the CRD, for the Community Registered Design itself. Prior arts at paragraphs 5 to 8. And the General Court agreed with the Board of Appeal that the registered design was for 2 and 4 distinct tonal colours, as opposed to the prior art, which produced a wide spectrum of colours. And that's paragraphs 49 and then 61 to 63 of that judgment. So, bearing in mind that my learned friend doesn't seek to suggest tonal contrast per se is not something protectable by the regulation, all he's seeking to suggest is a particular form of the representation should always be, in this particular form, should always be understood to be shape alone. We say that argument is at Clare against it. Yes. Now, yes. So with that in mind, we go to the next issue, which was the overall impression of the registered design with the kiddie case. We've set this out at paragraphs 81 to 88 of our case. There is no issue between the parties that both the Court of Appeal and Mr. Justice Arnold applied the right law to this question. Our point in relation to this is that once an error of principle has been committed by the trial judge, which involves ignoring a feature which is protected, the Court of Appeal is required to make its own assessment, having corrected that error. And that is precisely what it's done here, and it's taken into account those additional features which we rely upon, the tonal contrast and lack of ornamentation, and for the reason set out in paragraphs 81 to 86 of our case. They were entitled to do so, and they've come to the correct conclusion. And as a result of that, they have held that the designs are different, both at a general and also at a detailed level. That's paragraphs 51 to 53 of the Court of Appeal's judgment. Now, my last topic has a number of sub-issues. It's a question of whether there's a need for a reference. I mean, obviously, my Lord's hands as to how you wish me to address this, but what I was going to do was just give you a very brief overview of our position in relation to each of the questions, and then, if you want me to address you in relation to why absence of surface declaration is a protectable design, if you wish me to, and then possibly make a few submissions in relation to the OM judgment and Apple and Samsung.
Yes, I mean, on the questions to be referred, you're already made submissions, really, haven't you, effectively?
I've made quite a lot of them already, yes.
Because that you're saying they shouldn't be referred because we should determine them in your favour, or they don't need to be determined.
Yes.
Is there anything else you want? I mean, if we accept that argument, or contrary to your submissions, we accept Mr. Hicks's primary argument, then we don't refer.
That's right. That's right.
And if we do refer on the whole, I'd have thought it'd be more sensible to consider the issues once we've given a judgment indicating what we think, wouldn't it?
That I fully accept. Just if there's any
But if there's
principle that's
If there are any points of principle you want to deal with, then of course you should deal with them. But subject to that indication, I think consistently with what I've said before to Mr. Hicks.
I'm grateful.
The proposition of law that you contend to be Act Clear is that it is possible to have a protected design feature consisting in the absence of ornamentation.
Absolutely.
And as I understand it, that's the only proposition of law on your case that arises.
That's right, Lord. And in relation to that, obviously, I rely on the fact that there are a number of courts in both this jurisdiction and other jurisdictions in the community which have accepted that proposition, not necessarily in conflict, but accepted that proposition as a protectable feature without demur. And in relation to that, obviously, we have the Apple and Samsung disputes. We also have the case which you haven't been taken to, and I probably just want to give you the references, is the Hennes case against Yves Saint Laurent, which is in the General Court.
Well, we were taken to it rather swiftly this morning.
Well, yeah, I apologise you were, sir. I hadn't appreciated you were. That's the one with the handbags. That's at G, tab 20, page 721.
Para 32.
Yes, I think we were invited to
Sure.
read paragraph 32.
Yep, that was the one we were taking.
Was that on the unit?
I think you invited us to take. I think
Yes,
the one that you invited us to go to paragraph 32.
Yes, I want you to look specifically at paragraph 37 for the point about the lack of adornment or the elegant formal simplicity of the design as being a feature of this particular registration and in contrast to the prior art. So that paragraph I'd ask you to have in regard. That was the Board of Appeals decision, and that was then approved by the General Court at paragraphs 40, 41 and 44. Do we have better copies of the image? If your copies of the prior art, which you'll see at page 72, are somewhat washed out, we do have some better copies to hand up with some clearer images.
Mine are completely unintelligible.
That's what I feared. We can hand those up. And I just rely on this as just yet another example where lack of adornment or lack of ornamentation was considered to be a feature which was protectable. Again, there seems to be no dispute between the parties as to whether it should or shouldn't be. There's yet one more example to the Apple and Samsung raft of cases. I should just very briefly, in relation to Apple and Samsung before OM, just make a a couple of observations which may not have been clear for my learned friends canter through that case. This is in G tab 10, first authorities one G tab 10. Whilst this was an invalidity hearing, it was an invalidity hearing in which the invalidity division had to consider or interpret the registered design on 5 separate occasions for 5 separate reasons. Firstly, they had to consider it as to whether or not the images themselves were contradictory, and therefore the registration was invalid. Secondly, as to whether any of the features were disclaimed before comparing the prior art. Thirdly, whether any of the features were excluded as solely dictated by its technical function. And then fourthly, on a novelty basis, before fifthly going on to consider it as against the prior art for individual character. And so as a consequence, it's not right to say that OM simply said this is a registration for shape. They didn't. They addressed it on a number of different occasions, and I could just show you the particular paragraphs that we would ask you to bear in mind. At paragraph 41, page 539 to 540,
Yeah.
you'll see that when considering the question of whether or not this was a design, whether or not there were inconsistent or contradictory representations, what Owen held was that this was an appearance of a product resulting from its shape and its surface. And that meets definition of design according to Article 3A. 2 points arise from that. So it's not shape alone. They relied on surface. Surface, again, just for the avoidance of doubt, is not one of the expressly mentioned features within Article 3A, but there was no suggestion by doing that they were falling outside the Article 3A.
Is there some other paragraph which
Yes.
indicates what the feature of the surface
Even better for me is paragraph 53, which has the last sentence. For these reasons, it should be considered that protection is not claimed for any of the 3 elements indicated dotted lines, and representation of lines should be considered to be a featureless, transparent front screen framed by a smooth, featureless casing. So that's probably my explanation, my best one. But then they go on and consider it in relation to technical exclusions and also for the prior art. And as to the prior art, we make the observation, Apple only needed to rely on the shape. Shape was enough for them to distinguish between any of the prior art. The registration was held to be valid, just taking into account the shape. That was held to be both novel and had individual character over. So in those circumstances, it is too simplistic to suggest that this is somehow an inconsistent judgment in terms of saying this is just another court finding shape as opposed to shape and absence of ornamentation. Yes. And finally, my lords, I should just I apologise for giving evidence, but it's self-evident that a CAD program can, of course, produce line drawings. There's no concern that when you're doing your computer-generated production of diagrams that you have to do it in this particular form. You could just simply produce line drawings. The days of draftsmen with ink and quill drawing the line drawings are long gone. They're all produced on CAD machines anyway. Unless I insist you further, my lords.
Thank you very much. Just confirming we didn't need any more help at this stage on references. Obviously, we won't commit ourselves to any particular line on that if we decide to make a reference without giving you further opportunity to make submissions when you've seen what we've got to say.
I'm very grateful, my lord.
Thank you very much, Mr. Van Heegen. Mr. Akins.
My lord, I'm grateful. Nothing further.
Is there anything you want to come back on?
My lord, just one small point on the issue of law that my learned friend was running. He started off by emphasising the fact that there was no presumption as to form in the way in which the representation should be taken. When it comes to the question of trying to determine what Magmatic should have done and the interpreting the design in this case, he's very keen to emphasise the fact that Magmatic could have filed for a line drawing.
Yes.
And in response to my Lord Newberger's question, the point is made that, well, there might be the possibility that a line drawing could extend, but standing back and looking at this to my learned friend's submissions as a whole, in effect he's coming down to the proposition that if it's a line drawing its shape, if you go into the grayscale area, then you're starting to cover surface ornamentation. And indeed, when my learned friend took my lords to the Hennies case involving the handbag, the issue in that case, when one looks at the registration, is that they are photographs where you can see the grain of the leather. So again, it's coming down to a justification that would come down to the form. And my learned friend is also keen to emphasise the fact that there is third-party reliance and there needs to be certainty on the register. And we say that extends, in terms of certainty, to all those registrations who are already out there, where it wasn't clear that a position was being taken, if it's the right position, which we say is in doubt, as to whether or not you should be filing as a line drawing for shape and as a grayscale or a photograph if one wants to start claiming absence of ornamentation. And my lord, one further point that actually arises from that is on the same point of principle, and that is that my learned friend was very keen to emphasise the fact that although he was seeking to interpret the relevant paragraphs from Mr. Justice Arnold's judgment as not being a matter of principle, he was keen to emphasise that Mr. Justice Arnold gave permission to appeal to the Court of Appeal on the basis that those paragraphs were a matter of principle, and the matter may not have got to the Court of Appeal if that wasn't the case. My lord, finally, I have the benefit of those behind me who have travelled, they're hearing officers from the Intellectual Property Office, and they were slightly concerned with my exchange this morning, particularly with Lord Carnworth, that I may have created the impression that sending the matter on a reference to the CJEU was a case of everybody getting together and trying to sort out how to deal with these matters. I mean, my lord, the way we put it is that stakeholders are there involved, and it's a proper judicial process to sort out matters where there is a lacuna in the legislation. And those behind me point out that questions of the type which arise in this case have been dealt by with the CJEU before, particularly in the context of trademarks. And my attention is drawn to the Siekman case, C27300, where the question was, could a scent be claimed as a trademark and could it be graphically represented? The Libertel case, C10401, where the question was, could colours alone form trademarks, and if so, how were they represented? And the Shield mark, C28301, where the question was, could sound or music form the subject matter of a trademark, and if so, how was it to be represented graphically? So, my lords,
what was that last number?
Sorry, C28301. It's the Shield mark case involving fleur-de-lis. So, my lord, we're saying that in the context, as we are now, of designs, the issue as to whether you can register something, and if so, how, has very much been the subject of references to the CJEU afore. And indeed, that is the proper tribunal to determine the matter on a pan-European basis. Yep. My lords, unless I can be of further assistance to you, I'm grateful.
We'll begin by taking you back to the judgment of Mr. Justice Arnold, just to clear up what we say he was doing in paragraph 69 of the journal. Could I begin by just picking up a point on page 244 of the core bundle?
Yep.
Paragraph 31,
Yes.
where he refers to the CRD.
Yes.
And he makes the observation in the final sentence that the
Yeah, we looked at
drawings are all monochrome and do not involve surface decoration. It was a point right at the heart and forefront of this part of the case. Then at 66, he refers to the controversial point. And the point he was making was this a Procter and Gamble type case in which the conclusion was the design was for shape only, so that only shape needed to be considered, and graphical decoration on the alleged infringement was to be ignored? Or was it a Samsung and Apple type case in which a line drawing was found by the court, albeit possibly on the basis of some sorts of concessions, but nevertheless relied upon by the court as being for a combination of shape and a positive absence of surface decoration? And of course, during the hearing, it was pointed out to him that it was monochrome and all the features we've discussed today. They are obvious for everyone to see. They're CAD drawings, and the wheels are darker than the rest of the body. Of course, that was drawn to his attention. The point being, though, is he assessed those and came to the conclusion that it was a Procter and Gamble type case for shape alone. And once he's decided it's for shape alone, the rest of his judgment follows, because then he only considers the shape of the CRD and the shape of the alleged infringements and concludes they are infringing. Could I just take you also to the Procter and Gamble case, just to make clear again what was being decided there? That's in the first authorities bundle, and we'll start at page 349, if we may. Yep. At paragraph 45, the rival submissions are summarised. So Mr. Carr, for the defendants, was saying it is shape plus, if you like, an absence of surface decoration. And Mr. Wyand, and you can see that at the end, was submitting that it should be a comparison of shapes alone. So he had in mind the shape or the shape plus a positive absence of surface decoration in mind. The second point he had to go on to consider is, if it's just shape, if that is what the design is it a like-for-like comparison? And he found it was a like-for-like comparison. Therefore, if it is shape alone, you ignore the surface decoration on the alleged infringement. And that point is not in dispute, the like-for-like point. Moving forward in the judgment to 355, what the judge is doing here is considering the alternative position that he was wrong and it was shape plus an absence of decoration. And he says, so if I had been of the view that the colours and graphics had to be taken into account.
Sorry, which paragraph?
This is paragraph 71. So page 355, what would be the position if I had to take that into account? And then he says, the predominant colour of the Airwick canister is white. So he's considering the alternative position. By the time it got to the Court of Appeal, or during the hearing of the Court of Appeal, Mr. Carr then abandoned the surface decoration point. So it's considered purely on the basis of shape alone. So it was exactly the same issue as arises in this case, and that is why Mr. Justice Arnold compares the Procter and Gamble type case, shape alone, with the Apple and Samsung type case. The next question then is, how do you decide what type of case you are in? And that is the submissions which I made relating to the interpretation of designs and approach to interpretation. Now, our simple submission is that it should be done in the context of the type of article in question. what I mean by design corpus or informed use is its context of type of article in question. And we say, and we suggested at first instance and on appeal, as we suggest now, that when one looks at context, that strongly supports the proposition that the design is for shape alone. But can I make it clear? We accept, of course, that's a decision for the court, in the sense that the court doesn't listen to one witness saying, I think it's for shape, and another witness saying, not. Of course that's the case. It's a matter for the court, but the court has to take into account the context of the article. And in support of that, I have 3 courts of appeal in Europe in the Samsung case, each taking the view that design corpus or context was relevant to interpretation of the designs. In Germany, for example, both in relation to the dotted line point and in relation to the question of whether more than one design was shown, and in the UK and in Holland. And then we have His Honour Mr. Justice Burse's different view, at least different to the extent that it should be an expert. Whether that it doesn't affect the outcome in this case. Certainly a matter for the court. It's a question of context. Now, can I make good the point that I did make the submission regarding context? And for that, I need to pick up the appeal bundle H, which is the additional bundle which had my Court of Appeal argument in it. If you turn to the first tab, at page 1058, I at 19 accepted it was a matter for the court, and of course then it's a question of through whose eyes, and I mentioned Appellant, Samsung and the informed user. I said it doesn't make a difference. It doesn't make a difference whether it's an informed user or an expert. You get to the same background. And at paragraph 21, the final sentence, I said the representation must be studied and interpreted in the context of the article it's depicting. Then in the second tab, we have a transcript of the oral argument. It's not complete because something went wrong with the recording towards the end, so it doesn't include all my submissions. But could I just highlight a couple of passages? The first is at page 1166, at lines 5 to 23. 1166. And I made exactly the same argument before the Court of Appeal as I now make. The argument is that this is some sort of suitcase, and some strange suitcase. You know that toys are often brightly coloured and often have different coloured components, typical of children's toys. So you can see I made that submission there. And then over the page at 1167, I also made the point at 12 to 15 about toy-like suitcases, which are objects likely to be brightly coloured. So if I can wrap up my submission by saying this, of course the judge saw that these were CAD drawings and not line drawings. Obvious. Of course he could see the gradations on the products, and he was shown the wheels were darker. And what he had to do, we suggest, and what he did, is balance up those factors against the countervailing factors and come to a conclusion. And he concluded that it was a design for shape alone. It was an assessment we say he was entitled to reach. And the way the Court of Appeal deals with it, as I made in my submissions in opening in 41 and 42, is first by making a reference to the fact that they're grayscale drawings, or CAD drawings. It's accepted, everybody saw that. And secondly, by making an argument which we say was the conclusory argument, the decision that you could only determine shape if you could only determine it was animalistic if you concluded there was an absence of surface decoration. The point being, it looks like an animal, whatever the decoration, if you exclude surface decoration and just focus on shape alone. So for those reasons, we invite you to uphold the appeal or to make a reference for the reasons we've already given.
For that argument and for managing to compress it so we finish at the witching hour, notwithstanding a late, longer lunchtime than anticipated. Thank you very much. We're also grateful to all those involved in preparing the written cases. Thank you. We will consider our decision and let you know in due course. Thank you very much indeed. The court's now adjourned.